All right, it's 26 minutes before 11 o'clock. Thank you for tuning in this Wednesday morning. It's Wednesday. You hear that music, and that means you know that John Fuller is in the studio ready to answer your questions. But what you don't know yet, if this is a live show. So here's how you know. I'm going to tell you today's date, and if your calendar shows the same date, then you're listening to a live show, and that is your invitation to call in to ask a question of John. The number is 622-9622, and today's date is Wednesday, January 15th, 2014. So if that's your date, go ahead and call in, John, ask your questions, and good morning, John.
Good morning, Larry. Good morning to everyone who's listening, and I hope everyone is enjoying a pretty day today. We've had mixed weather. It's been hot, it's been cold,
Right.
It's been wet, it's been a little bit of everything, but today looks nice. So it's good to be here with everyone, and hopefully we can answer some questions or talk about some issues that folks may have with the legal system or involving issues that they or their family or loved ones have. I know and there's been in the press a lot lately some tragic accidents and that sort of thing, and that's a very trying time for folks. And if you or a loved one are in an automobile accident or something like that, it's very important to do a few significant things. Number one, first and foremost, get medical attention. Do it timely. You must do it within 14 days after the accident. And the doctor that you see, you need to talk with him about all of your symptoms and be a good historian. If you have a question, the best thing to do is to seek legal advice. And obviously, if you care to, we'd be happy to talk with you. Our phone number at the Fuller & Fuller Law Firm is 352-547-4292, and get specific answers concerning your specific case. But generally speaking, you want to make certain that you seek medical attention and that you are thorough and complete in explaining any injuries or symptoms that you may have, so the doctor can make good records. That's very important. Take care of your health. That's number one. Number two is seek legal counsel, because the person who may be at fault, if they have insurance, they'll have a professional adjuster who will be looking after their interests to try to resolve the case and to minimize the amount of damages that they pay. You should have a champion on your side who will see that you get fair and just compensation for the injuries and damages that you have. Not only that you suffered in the accident and up to the time you see a professional, but what are your damages in the future going to be? Are these injuries going to affect your ability to work and earn money and that sort of thing? So just wanted to mention to our listeners, if you or a family member or a loved one have been in an automobile accident in which you feel that the other driver was at fault and you've suffered serious injuries, give us a call. We do not charge any fee or costs if we don't make a recovery for our clients in those cases. And it's very important because a lot of questions are determined by physical evidence. And physical evidence is something that is subject to disappearance. Skid marks wear off of pavement. Right. Automobiles that are crushed are ultimately sold for salvage and taken away. Eyewitnesses locating them and talking to them, their memories are better and sharper about what they saw if you can talk to them quickly after the incident than if you don't get involved until several months later. So, and not every person who is in an accident has a case, but it doesn't hurt to consult with a professional, and certainly if we can help folks, that's something that we do. It's a very trying time on the family, of the individual who's hurt. So
Yeah.
I wanted to mention that because we haven't talked about it in a while. We've gotten off on very interesting legal topics involving the legal system and courts and mediation and different legal issues, which are all fascinating and which we welcome and try to address those in general terms as to the best of our ability. But if you're hurt, you need to have someone on your side, and we'd certainly be happy to talk with you about it.
Does the reparation part of the person who pays always come from the other party? Let's say you looked at it and you said, you know what, this was really the fault of the road. There was something wrong with the road, or there was something wrong with the car, maybe the manufacturer of the car.
There could be multiple defendants that you would look to that would be involved. So each case is different. So it's just something that people need to make sure they are protected. And I'm happy we have a call.
And yeah, as I was asking, I apologize. I shouldn't have asked, but there was a call coming in. By the way, everybody is invited to call. The number is 622-WOCA. If you have a question for John, go ahead and call. Just let it ring while we're talking, and I'll get to it as soon as we can. The number is the WOCA Climate Control Source Hotline, 622-9622. Good morning. Thank you for your patience. You're on the air with John.
Good morning, John.
Good morning. Thank you for being patient and waiting for us. I appreciate you calling in. How are you today?
Well, I wait all week for your program, so just a few minutes, there's no problem.
Well, that's awfully kind. Thank you.
The question is, on a plea bargain, can the judge overrule and deny that?
I'm having a little technical difficulty hearing your question. Would you repeat it for me, please?
Sure. On a plea bargaining situation, can a judge overrule it and deny it?
Yes, under the Florida Rules of Criminal Procedure, plea bargaining is an accepted and appropriate exercise to take place in a criminal case. And it takes place between the prosecuting attorney and the defense attorney. But the judge has the last say in whether or not he will accept a plea bargain. Now, let me make a quick distinction because a lot of people get confused here. The judge, if the prosecutor and the defense lawyer agree that the defendant will plead no contest to the offense and will be placed on probation, and the judge looks at the case at the status conference or the pretrial conference and says, I don't agree. If he's going to plead no contest or guilty to this offense as charged, I'm going to sentence that individual to 1 year in jail and then 1 year probation thereafter. The judge has that right. He will, the person who is then engaged in the plea negotiation has the right to then say, well, I'll go to trial and let a jury decide my guilt or innocence. My decision to enter into plea bargaining was a decision that was made in my best interest while maintaining my innocence, but simply to resolve this, to avoid a trial, to avoid the cost, and to have certainty, closure, and finality to this event in my life. Now, that's plea bargaining. The judge can say, I accept it or I reject it, or I'll accept this with additional punishment, if you will. Now, there is another aspect known as charge bargaining. And the person that has the unlimited authority is the prosecuting attorney, either the state attorney at the state level or the U.S. attorney at the federal level, acting through their assistant state attorneys or the assistant United States attorney. And they can decide out of the facts, there are multiple criminal offenses that might be charged. So if you have a judge that says, I won't accept that plea on that charge to that offense, I want to have a greater degree of punishment. If the prosecutor feels that the facts warrant it, he could dismiss the charge that he filed and file a lesser included charge that carried a lesser penalty. He could even charge a lesser crime and get it in a separate court if he so chooses. The prosecutor is the very first judge and jury of the facts of every criminal case that occurs. So often when I do a criminal defense law, I like to try, if possible, to have a meeting with the prosecutor before any charge is filed and show the other side of the story, if you will, in hopes that I will be able to have the prosecutor make a decision that is consistent with the facts and that we can agree to. Prosecutors take an oath. It's not about them winning the case. It's about them seeing that justice is done.
Yeah.
And they have a duty for that. And so but they have to have facts to base their decision upon. And a lot of times they make their decision before the defendant even gets involved in the process, based solely upon what the complaining witness and law enforcement tell them. And they don't always have the scales balanced, if you will, at an early stage. So that's, I hope, answers your question. But in plea bargaining, when it comes down to sentencing, the judge always has the last say.
Okay, well, thank you. You certainly answered my question. Thank you very much.
Well, thank you
Good
for
day.
calling in. Appreciate your listening.
I know.
And plea bargaining, sometimes, I guess every story is different, but it sounds risky sometimes.
What is that?
Like taking a plea bargain, like it's almost like you're trying to get a lesser penalty, but at the same time, maybe you don't even say you're guilty. I mean,
Well, yeah, it's it's a calculated decision that the defendant has to make the decision based upon what he thinks,
Wow.
he or she thinks is in their best interest. Going to a jury trial is a scary, fearful, fearsome event.
yeah.
There is no predicting what a jury will do. And if you are at risk for a substantial jail sentence and you are able to negotiate a plea that has a much reduced jail sentence or probation, even if you are not, quote, guilty of the offense charged, if it is in your best interest to have certainty. In other words, if you're charged with an offense for which you could go to jail for a maximum of 5 years, and they offer you a plea to probation, that's pretty hard to turn down for a person who would then be on probation and keep his or her liberty and freedom to go to work and see their children and go to their school events and participate in their daily lives, as opposed to spending 5 years in prison if they're convicted. And when you go to a jury trial, there is a huge element of uncertainty, no matter how strong the evidence is and how innocent the client actually is. Jurors, I think, do a wonderful job. I am a big proponent, big admirer of our jury system. It's the best system in the world. In most every case I've been involved with, I think it has worked and worked properly to the benefit of society and to our citizens who find themselves accused of an offense, a criminal offense. But it's not perfect. No system that man is involved with is perfect, because we
Right.
aren't perfect people.
Right.
Mistakes are made. That has been shown over and over and over in the Innocence Project, which started a number of years ago when DNA evidence became so reliable, and they were literally scores, maybe hundreds of people who had been convicted of capital offenses and were on death row
Yeah.
and were exonerated by DNA evidence that they were able to utilize 5-10 years after the alleged crime
Wow.
occurred, and it showed that the individual who was convicted after a jury heard the evidence and appeals were taken, and they're sitting there on death row, and they were found to be proven to be, by this DNA evidence, that they couldn't have committed the crime.
Wow.
And they were released some after 10, 20 years. So it's not a perfect system. There's nothing that I've ever been aware of is, quote, perfect.
Yeah, right. Let me invite the listeners to call if you have a question for John. Remember, you're listening on Wednesday, January 15th. 2014. I tell you the date so you know if you're listening to a live show or not, because sometimes John is in court on Wednesdays. So right now, if you're listening on January 15th, 2014, and you have a legal question, go ahead and call 622-WOCA, the WOCA Climate Control Source Hotline. The story about the young woman, the mom, who was on trial in Ocala for the death of her 2-year-old daughter.
Yes.
This is more of a question about clothing. It looked like she was dressed to look demure or something. Is that something she would decide? And you, as attorneys, do you sometimes tell your client, cut your hair, shave, wear certain clothes? Does that actually come up as a way to help the case?
I think, and I tell people when they go to court, this is a serious matter that you should be dressed in a respectful, appropriate manner, much as if when you went to church or you went to some solemn, important occasion. So, yes, I do tell people, look, I don't want you to dress some way totally different that's not yourself, per se, but we want to show respect to the dignity of the court, the judge, the process. So you dress in your nice clothes. Dress, I don't tell people to go out and buy a coat and tie if they don't have the money to do it or they don't normally do that. But I tell them, wear the nicest clothes, the most appropriate clothes that you have. You wouldn't wear a party dress to church, and you wouldn't want someone wearing a party dress to court. You wouldn't want someone wearing a torn-up, battered pair of paint-splattered jeans and work boots and a T-shirt to church. You would want them to wear, at the very least, a pair of khaki pants or a clean pair of jeans and the nicest shirt that they have. So those things, yes. You want folks to be themselves, not to appear to be something that they're not necessarily, but to make a good appearance.
That makes sense, right? All right, and you have another phone call. Good morning. You're on the air with John.
Hey, good morning, John. Good morning, Larry.
Hey.
Good morning.
Man, you couldn't have hit a better subject there. I just spent 2 days at the local courthouse jury service. I don't know what people are thinking. But anyway, got a question for you, talking about what they wear. It's like, it's just no respect whatsoever. I got a question for you, not specifically the case that I was on, but they said there was 2 people in a motor vehicle going down the road. One of them didn't have a seatbelt on. They pulled him over. They found an illegal substance under the driver's seat, and they were trying to figure out who was actually in possession of that substance. And could you kind of make it easy to understand how you determine who is actually in possession of it if it's under receipt of a vehicle? I'll hang up and get the answer, and I like your show.
Well, thank you for calling, and before we do anything, thank you for your service on a jury. That's one of the, you have 2 duties as citizens of this country, and that is, 1, to serve on a jury if called, if you're not otherwise disqualified or unable to serve, and 2 is to go to the polls and exercise your right and duty to vote for elected public officials. I feel very strongly about it. I want to commend this gentleman for serving and carrying out his civic responsibility as a citizen, and so I want to thank you for that. Number 2, I couldn't answer you. I'm sure the court, as you heard the evidence at the close of the evidence, gave you the appropriate jury instructions on the standards to determine what is actual possession versus constructive possession. And it's a little bit complicated and a little bit beyond the scope of this show, especially when you've already been involved in a case in which the court has informed you and advised you of the law. Generally, if the substance is within an area that is under your possession and control, in other words, it is readily accessible to you, that can be proven to be possession or constructive possession. If you happen to be just in a two-bedroom suite in a hotel, and you are simply in the living room area, and there is a complaint that a party is going on, and law enforcement officers come in and find a controlled substance in the bathroom of one of the bedrooms where you are not and have not been, then that would not be, in my judgment, sufficient evidence to prove that you were in possession of a controlled substance. It is an involved issue, and it is dependent upon the facts of the case as to what is possession, what is actual possession, what is constructive possession, and those things are determined by the specific facts as applied to the principles of law that the court would have instructed you on during the trial. So I won't hazard any more generalized comments, but at the end of every trial, the judge gives the jury legal instructions and explains to them what the law says concerning the particular case they are involved with. If it's an automobile accident, the judge explains to them what are the elements of negligence and what are the recoverable damages if they determine that one party was negligent, and what is causation. Same thing in a criminal case. If you are charged with a vehicular homicide, the court will explain to you what are the elements of vehicular homicide. If you are charged with DUI manslaughter, the court will explain to you what are the elements. And then the court will explain to the jury that the prosecutor has the burden of proving each one of those elements. Every criminal offense is made up of little building blocks that are elements of the offense, and the prosecutor has the duty to prove each one of those elements beyond and to the exclusion of every reasonable doubt. And if the prosecutor fails in that burden, the court tells the jury, you must return a verdict of not guilty. And then the court explains to the jury what is the burden of proof, what is the presumption of innocence, so that when the case is all over and the jury goes back to deliberate, the jury has a good understanding of what the elements are, what the burdens are, and what the standards of proof are, and then their job is to determine, do the facts that were presented in evidence, and not all facts get admissible into criminal court. We don't let hearsay evidence come into our trials unless it meets one of the various exceptions to the hearsay rule, because generally our system as a whole has determined that hearsay evidence is not reliable to have sufficient probity value to let someone come in and say, well, somebody told my cousin who told me that they saw XYZ. That's not admissible. So there's a lot of things that go into a trial, and that's why everyone who is facing any type of a legal process needs to have the services of a lawyer.
So getting back to the possession of the substance that was illegal, if a police officer finds such a substance, do they impound the car And I guess part two to that is that why it's important to know who owns it? If the driver, the owner of the car, owns the substance, then they take the car. But if the passenger owns the substance, do they not take the car?
Well, if the person who committed the offense owned the vehicle, then the vehicle would be subject to a forfeiture action, which is a separate procedure and a separate hearing on that.
Okay.
So they can't just automatically take something if it was involved in a criminal event unless they show some nexus between the person who owned the vehicle being involved or at least knowledgeably involved with what occurred. I had a case a number of years ago where an innocent party entrusted a large sum of money to a friend who had a license to go to a car auction to buy automobiles, and she wanted to purchase an automobile, and he was going to the car auction to purchase the automobile, so he had a substantial sum of cash on him to go purchase the automobile. He did not do that without her knowledge or any indication whatsoever. He was arrested and charged with using that money trying to purchase a controlled substance from an undercover police officer.
Oh, no.
He was charged in the criminal case, and then the Marion County Sheriff's Office started a forfeiture action to forfeit the cash money that was there.
Oh, wow.
I represented the lady, was able to show, number one, she had recently sold the vehicle that she had and did not have one.
Right,
Number two, her husband had died. She had no family. She needed a vehicle. She had gone to her bank, withdrawn the money, had written on the withdrawal ticket that it was to purchase a car, and had entrusted the cash to this individual who did in fact have a license to purchase vehicles at a car auction. And there was in fact a car auction going on at the time the gentleman came and got arrested and charged with allegedly using the money for other purposes. We had a hearing on that before one of our circuit judges, and the court ruled that the evidence was not compelling, that our client had any knowledge or involvement, and she fortunately got her money back.
Wow.
Let me go on to another stage. Actually, as the facts developed in that case, the attorney on the other side, who was representing the sheriff's department at the time, agreed with me. And ultimately, after preliminary hearings and evidence and that sort of stuff, ultimately agreed with me that my client was a victim of circumstance. And at the last analysis, at the last hearing, when we were going to have the trial, did not contest it, and the court ordered it released.
That was good.
So lawyers have a duty. This is what I was saying about prosecutors.
Yeah.
Prosecutors have a duty. Not just to get a victory, not just to go and argue and just take a position and argue it, but if they don't believe that based upon their good faith investigation that the facts support the elements of the offense, they have a duty to dismiss that case. And so that's how the system
is the whole
works.
thing, right?
That's the goal. Sometimes it is a very ephemeral, hard to obtain result, but you keep battling.
Bet she was glad she had you on her side.
You keep battling.
John, what's your phone number?
Well, our office number is 352-547-4292. We have offices in Ocala and the Villages. Our toll-free number is 855-534-2565. And before we finish, Larry, I just wanted to say good wishes to my father-in-law who fell and broke his knee last week. He's a very spry 88, but he's been limited by that. And we spoke earlier about if you are injured, it's important to get good medical care, and I have seen that firsthand. And so he often listens to this show and watches it on the podcast. So I want to give a big hello and best wishes to Bob and hope that he has a speedy recovery.
There you go. And I apologize for knocking over the camera. Just
No, that's okay.
So if he was watching,
that probably enhanced the quality of this show greatly if you took the video camera down so I didn't appear. That probably was a good thing.
It was a momentary tumble. Yeah. Thank you, John. Always great. It's amazing listening to you. It helps us understand why people go to you for help. Thank you, John.
Well, thank you, Larry. It's a pleasure, and thanks to our listeners who called in.
We need to move forward. We'll take a little break and be right back.
Ocala's information station, 1370 WOCA.
Ocala. ABC News Now. I'm Karen Chase. New evidence that this year's flu strain is particularly vicious. Michigan health officials say 320-somethings with no otherwise underlying health problems